Today we are going to discuss on the European Convention for the Protection of Human Rights and the Fundamental Freedoms of 1950. Introduction. The European Convention for the Protection of Human Rights and Fundamental Freedom was the first comprehensive treaty in the world in the field of international human rights. It was established first international complaint procedure and the first international code for determination of human rights matters. It remains the most judicially developed of all the human rights system. It has generated a more extensive jurisprudence than any other part of the international system, and it now applies to almost 25% of the nations in the world. The importance for the adoption of European Convention came from three factors. First, the regional response to the atrocities committed in Europe during the Second World War and are less likely to wage war on their neighbor. Second, both the Council of Europe and European Union were partly based on the assumption that the best way to ensure that Germany would be a force for peace in partnership with France, United Kingdom and other West European states was through regional integration and the institutionalization of common values. Third, the desire to bring the non-communist countries of Europe together within a common ideological framework and to consolidate their unity in the face of the communist threat. The Council of Europe. In the aftermath of World War II, European states formed the Council of Europe with the aim to achieve a greater unity for the purpose of safeguarding and realizing ideals and principles which are their common heritage and facilitating their economic and social progress. Integral to Council's aims was the formulation of the Convention for the Protection of Human Rights (CEC-UGC) to protect the right of citizens of Europe and to ensure that all human rights abuses committed in World War II were not repeated. Today, the CEC-UGC has 47 signatories and provides constantly evolving human rights protection to over 800 million people. The Council has further extended human rights protection with the creation of other treaties, including the European Social Charter, the European Convention for the Prevention of Torture and other cruel, inhuman or degrading treatment or punishment, and the Framework Convention for the Protection of National Minorities. The European Convention on Human Rights. The CEC-UGC came into force in September 1953 and represents the minimum human rights protection a state party must guarantee to its citizens. Rights under the Convention can be absolute, derogable or qualified. States may never derogate from obligation to uphold absolute rights. Absolute rights include the right to life under Article 2, except in respect of deaths resulting from lawful acts of war. The prohibition of torture, Article 3. Prohibition of slavery, Article 4, Clause 1. And the prohibition of punishment without law, Article 7. Other articles in the Convention may be derogated from in some circumstances, provided that this is not inconsistent with a state's other obligation under international law. Article 15 allows all non-absolute conventions rights to be derogated from in time of war or other public emergency threatening the life of the nation. Derogable rights may also be expressly qualified in the convention. Rights containing express limitations are termed qualified and include the right to respect for private and family life, Article 8, freedom of thought, conscience and religion, Article 9, and freedom of expression, Article 10. A state may only limit qualified rights if the qualifications imposed are prescribed by law and are necessary in a democratic society. Limitations may also be proportionate to the legitimate aim pursued. Legitimate aims include interest of national security, territorial integrity, or public safety, for the prevention of disorder or crime, for the protection of health or morals, for the protection of the reputation or rights of others, for preventing the disclosure of information received in confidence, or for maintaining the authority and impartiality of the judiciary. 6 subsequent protocols have further expanded the substantive protection offered by ECHR. There have been 14 protocols to the ECHR, 8 of which relate to procedural matters. To come into force, protocols containing substantive rights may be ratified by a minimum number of states as specified in the protocols. Protocols altering procedure enter into force only when ratified by all contracting states. However, applications alleging violation of rights contained in the protocols can only be brought against states that have ratified them. The rights contained in the ECHR, including the additional protocols, are in the main civil and political. Most of the rights protected offer security to the individual, with few rights pertaining to groups. This is exemplified by the lack of protection granted to minority groups as groups under the convention. However, individual rights as freedom of assembly and association do enhance the protection of groups to some extent. Most of the rights included in the ECHR can be found in other international and regional human rights law treaties, including the International Covenant on Civil and Political Rights (ICCPR). However, the absolute prohibition of the death penalty containing in Protocol number 13 is unique to the Convention. The preamble to the European Convention refers to the European countries which are like-minded and have a common heritage of political tradition, ideals, freedom, and the rule of law. The above points which describe the European Convention is known as genuine democracy or effective political democracy. The preamble constitutes only the first steps for the collective enforcement of certain of the rights stated in the Universal Declaration. The European Convention was signed in Rome on 4th November 1950 and entered into force on 3rd September 1953. A central feature of this regime is the right of individual and interstate petition, and at the request of the Committee of Ministers, the European Court of Human Rights may also give advisory opinions on the interpretation of the Convention and the protocols. The court came into being in 1959 and gave its 10,000th judgments in September 2008. The role of the court and of the European Commission and court in the arrangement proceedings, the entry into force of Protocol 11 in 1998 and the Committee of Ministers is that of review and not that of an appeal court from decision of the national tribunals. Their task is to ensure that the standard of the convention and its protocol are observed by the administration of the states concerned. The work of these institutions has had important consequences. Valuable materials have been provided for the elaboration of the provisions of the civil liberties. The anomalies have been exposed in national system of law, often with the result that the relevant national legislation have been changed for the better. Several individual cases have also served effectively at test cases and or have raised issues affecting a whole class of persons, for example, a linguistic minority. Right recognized in the ECHR. The European Convention adopted various provisions relating to the rights and freedoms to secure to every high contracting parties to the Convention. Section 1 of the Convention prescribes rights and freedoms such as right to life, Article 2, prohibition of torture, Article 3, prohibition of slavery and forced labor, Article 4, right to liberty and security, Article 5, right to fair trial, Article 6, right to respect for private and family life, Article 8, freedom of thought, conscience and religion, Article 9, freedom of expression, Article 10, freedom of assembly and association, Article 11, freedom to marry, Article 12, right to effective remedy, Article 13, prohibition of discrimination, Article 14, prohibition of abuse of right, Article 17. By May 2012, all 47 member states of the Council of Europe were parties to the European Convention and protocols number 2, 3, 5, 8, 11 and 14. Following the entry into the force of protocols number 2 EST number 155 on 1st November 1998, the control machinery was substantially restructured. All alleged violations of human rights are referred directly to the court. In most cases, the court thereafter sat in chambers of 7 judges, decided on the admissibility and the merits of applications and, if necessary, undertook an investigation. The court also made itself available to the parties with a view to securing a friendly settlement on the basis of human rights as defined in the Convention and protocols. The revise proved inadequate to the task and further reforms have now been adopted. The temporary impasse in the ratification process led to the adoption of Protocol number 14, but this has been now superseded with the entry into force of Protocol number 14 on June 2010. European Codes and its procedure. The European Convention provides establishment of European Code of Human Rights under Article 19. It provides for both individual petition under Article 34 and interstate complaints under Article 33. The individual petition brought by individuals, legal persons such as corporations, groups of individuals or NGOs have grown exponentially in numerical terms. The Convention makes clear that the primary responsibility for implementation rests with the member states themselves. The implementation machinery of the Convention comes into play only after domestic remedies are considered to have been exhausted. The great majority of complaints submitted are deemed inadmissible, frequently on the ground that domestic law provides an effective remedy for any violation that may have taken place. The obligation of the member states under Article 1 and Article 13 of the Convention to secure to everyone the Convention's rights and to provide an effective remedy before a national authority for violation of those rights. The remedy given by domestic court may be pursuant provisions of the domestic law that stand relatively independently of the Convention, although perhaps influenced by it, such as Human Rights Act, a Code of Criminal Procedure, or a constitutional procedure that are consistent with the Convention, or a remedy may be given as a result of the incorporation of the Convention into domestic law. In terms of institution, all complaints were first considered by the European Commission on Human Rights. It initially considered whether a complaint was admissible. If it was, an effort was made to broker a friendly settlement as provided for in the Convention. In the absence of such a settlement, the Commission reported on the facts and expressed its opinion on the merits of the case. That report went to the Committee of Ministers, a political body which could endorse or reject it. For instance, whether states concerned have opted to accept the compulsory jurisdiction of the court. Either the Commission or that state could refer the case to the court for a final binding adjudication, including where appropriate, and an award of compensation. The court was thus dependent on the Commission or the state concerned in order to be able to consider a case. A major reform introduced in 1994 when the Protocol number 9 entered into force allowed applicants to submit their case to a screening panel composed of the 3 judges, which decided whether the court should take up the case. Interstate Procedures. Article 33 of the revised Convention contains a procedure by which one or more states may allege breaches of the Convention by another state party. This procedure has generally been used very sparingly in relation to the member state of the European Union. This sparing use is likely to be reinforced by Article 7 of the European Union Treaty. The European Court's interstate procedure will continue to be the only option in relation to disputes between non-European Union member states. Between 1956 and 1999, the former Commission considered 17 interstate applications, the most significant of which address only 3 different situations. Number 1. Greece versus United Kingdom in 1956 and 1957 relating to the declaration of a state of exception to Cyprus. Number 2. Austria versus Italy in 1960 concerning the murder trial of 6 members of the German-speaking minority in the South Tyrol. Number 3. Denmark, Netherlands, Norway and Sweden versus Greece in 1967-1970 relating to the coup d'etat carried out by the Greek colonists in 1967. The court's jurisdiction of European Court cannot be considered an application unless it ascertains that it has jurisdiction over the case. If an event occurred prior to the state becoming a party to the European Court and has no continuing dimension, if the state whose conduct is complained about is not a party to the Convention and so on, the court will have no jurisdiction. The issue of extraterritorial jurisdiction arises in connection with the situations which have become increasingly common. For example, situations in which a military strike is launched from within the legal space of the Council of Europe but results in damage outside that area. Actions taken by armed forces of one state operating in the territory of another, which may or may not be a member of the Council of Europe, and the responsibility of a state contributing troops to UN or other multilateral peacekeeping force under the UN Security Council. Conclusion. Despite the effectiveness of the above mentioned provisions of the European Code, is currently facing considerable pressure to change its approach in a variety of ways. Some of the disadvantages of the Code are a small budget and lack of staff system and increasing number of workload, etc. There are some long-term future of convention system, and the Code is effectively implementing at the national level. The conventional system must support states in fulfilling their primary responsibility to implement the convention at the national level to make it more comprehensive and effective for protection of human rights of the European Union.